we get it. Navigating custody, alimony, child support, or dividing property in a Minnesota divorce isn't just stressful, it's also awfully confusing. That's why we launched the Minnesota Family Law and Divorce Answers podcast. In each short episode, we break down the most common legal questions we hear every day from clients across Minnesota and give you practical advice you can actually use. Whether you're in the middle of a divorce, just starting to think about filing, or trying to make sense of post-decree issues, this podcast is built for you. Brought to you by Jason Kohlmeyer of Kohlmeyer Hay Gun Law Office.
Welcome to this deep dive.
Glad to be here.
Today we're tackling something really common, but often pretty confusing for anyone navigating post-divorce life, especially here in Minnesota.
Yeah, absolutely.
We're talking about figuring out what happens to your child support order when incomes change.
It's definitely one of the most frequent questions people have. You know, after the initial divorce is done, life happens, right? Jobs change, salaries shift, and those original numbers can suddenly feel, well, wrong, outdated.
Absolutely. And to really get a handle on this, we're digging into a great source today. It's a legal blog post from a family law attorney right here in Minnesota.
Oh, nice. So someone in the trenches.
Exactly. They've pulled insights straight from their case experience and, really importantly, from the specific Minnesota state statutes that actually govern this whole area.
Okay. So our mission today really is to cut through that complexity. We want to give you the core rules, the practical steps, the specific numerical guideposts you need to understand how these income changes can impact child support, specifically in Minnesota.
We're talking about getting straight to the point. Like, what does the law actually mean by a substantial change? Why could waiting even just a few months to act cost you, financially speaking? And what kinds of income changes will the court actually take seriously? And which ones won't fly?
Yeah, those are the key questions. Let's unpack this.
Okay, so before we dive into the changes, maybe just a super quick refresher. Yeah. How does Minnesota figure out child support in the first place? Like the initial order?
Sure. So the state uses a pretty specific guideline formula. It's designed for consistency.
Okay.
It looks at both parents' gross monthly incomes, that's before taxes.
Right.
It considers the number of overnights each parent has with the kids over the year.
Okay, parenting time.
Exactly. And then it adds in certain specific costs, like the children's share of health insurance premiums and any work-related childcare costs.
Gotcha. So it mixes income, time, and key expenses.
Right. The idea is to create a standard sort of predictable way to calculate support based on those main factors at that specific time.
A snapshot. But, like you said, life keeps moving. That snapshot gets old, incomes go up, incomes go down.
People lose jobs, start new ones, change careers.
Right.
And that movement, that's what sometimes triggers the need to revisit that original court order.
Okay, so the source lays out basically 4 ways income changes could potentially affect child support. What are those core scenarios?
It's pretty straightforward, really. It's either 1, your income goes down.
Okay.
2, your income goes up. 3, your ex-partner's income goes down. Or 4, your ex-partner's income goes up.
Simple enough. 4 main possibilities.
Right.
Now, based on the source, which of those tend to be the most common reasons people actually go back to court seeking a modification?
Well, according to the attorney's experience reflected in the post, the most frequent triggers are usually one of 2 things. Either the parent who's paying support has had their income drop significantly.
Right. Making it hard to pay.
Exactly. It's become unaffordable, or the other parent's income has increased substantially.
Suggesting the support amount maybe should be higher now, according to those same guidelines.
Precisely.
So, okay, let's say one of those big changes happens. You lost your job, or your ex got a huge promotion. You don't just, call the courthouse and tell them, right. It's not that easy.
Chuckles slightly. No, definitely not. If only. No, it requires a formal legal process. This whole thing is governed by a specific law, Minnesota Statutes, Section 518A.39.
Okay, 518A.39.
Yep. That statute is the foundation for asking for a modification. It says you can ask the court to change an existing order if there's been a substantial change in circumstances.
There's that phrase.
That makes the current order, and this is key, unreasonable or unfair. And income changes are a very common type of substantial change.
Okay, substantial change, unreasonable or unfair. Those words sound like they could mean a lot of different things. How do the courts or the law actually define substantial when we're talking just about income?
Right. And this is where the source gives us some really critical specific details. Because while the statute uses those broader terms, unreasonable or unfair, The attorney writing this blog post really emphasizes something important based on their 2025 perspective,
Which is?
which is that courts nowadays rely very heavily on that child support guideline calculator we mentioned earlier.
Back to the calculator.
Exactly. Arguments based purely on a feeling of this isn't fair anymore, without the actual numbers from the calculator backing it up according to the guidelines.
Yeah.
Those arguments rarely succeed on their own.
Okay, so it really boils down to the math, the calculator's output. So what are the specific numerical thresholds? What does Minnesota law presume is a substantial change based on income?
Okay, here's the real takeaway on that. The law creates a presumption, basically. The court assumes it's substantial if, when you plug the new incomes into that child support guidelines calculator,
Yes.
the result is a child support payment that is at least 20% higher or lower than the current existing order amount.
20%. Okay.
And it's usually a two-part test. That 20% change also results in the payment going up or down by at least $75 per month.
Wow. Okay, so it's not just one or the other. It has to hit both. A 20% difference and a minimum of $75 a month change. That's very specific.
It is very specific. Now, there's one small exception mentioned. If the current child support order is already less than $75 a month to begin with,
Okay.
then the threshold is just the 20% change. The dollar amount doesn't have to be $75 in that specific low order case. But for most typical orders, yeah, you need to meet both criteria, the percentage and the dollar amount.
Okay. And the source gives a pretty clear example, right? If the original support was, say, $500 a month,
Right.
and you run the numbers with the new incomes, maybe your ex's income went up, and the calculator now says the guideline amount should be $600 a month.
That hits the mark. That triggers the presumption, because going from $500 to $600, that's a $100 increase. $100 is exactly 20% of $500, and obviously $100 is more than $75.
Got it. Hits both numbers.
So hitting those specific targets creates that legal presumption that, yes, a substantial change has occurred, and the order should likely be modified.
But interestingly, the attorney also notes that judges can still consider cases that don't quite meet that strict 20% and $75 rule if there are other sort of compelling circumstances.
That's true. While the calculator and those numerical thresholds are, really powerful tools for the court, there's still some room for judicial discretion. Judges can look at the bigger picture, the overall financial situation, the specific facts of the case.
And they give that interesting example about retirement to kind of illustrate that point, about courts sometimes looking beyond just the strict numbers.
Yeah, that was an interesting case mentioned. The source described the situation that, it's important to note, this case was technically about modifying spousal support, or alimony, not child support, but the principle is useful.
Okay.
It involved a man who was earning, I think, $120,000 a year. He retired, and his income dropped drastically down to about $19,000.
Wow, that's a huge drop.
Huge. And even though the retirement itself was voluntary, the impact on his income was so significant, so drastic, that the court found the original spousal support order had become unreasonable based on this new reality. They allowed it to be modified.
So it shows that sometimes it's not just about hitting a precise percentage on a calculator.
Yeah.
A judge can recognize when a massive income shift just changes the entire landscape.
Exactly. It demonstrates that courts can consider the real-world effect, although the source does add a little caveat.
Oh.
Yeah, they mentioned there's a newer spousal maintenance law that came into effect in 2024, which might change how courts look at retirement income specifically in spousal support cases going forward. So that adds another layer of complexity for those specific situations.
Okay. Good to know. But all of this, whether it's hitting the numbers or having compelling circumstances, it highlights something absolutely critical that the source really hammers home.
Which is?
This change, this modification, it doesn't just happen automatically when your income changes.
This is probably the single most crucial, practical piece of advice in the whole article.
Yeah.
Yes. If you believe your child support order needs to be changed, whether it's because your income went down or your co-parents went up, whatever the reason, you must take action. You have to formally file a motion with the court asking for that modification.
And the reason you have to file that motion is deeply connected to when any change might actually take effect, right? The effective date.
This is absolutely key. In Minnesota, the general rule is that courts can only make modifications retroactive, meaning going back in time to the date you actually filed your motion with the court clerk.
Whoa. Okay, say that again. Only back to the filing date?
Generally, yes. They typically will not go back to the date your income actually changed, or the date you lost your job, or the date your ex got the raise. They go back to the date your legal paperwork requesting the change was officially filed.
That is huge. That means if you find out about a major income change today, but you wait, say, 6 months to actually file the motion.
You could be losing out significantly. If your income dropped, you might have overpaid support by a substantial amount for those 6 months, money you likely won't get back.
Wow.
Or if your co-parent's income went way up, you might have missed out on 6 months of potentially higher support payments that you could have been entitled to under the guidelines.
So that filing date essentially starts the clock for any potential adjustment.
It's your start date. That's why the practical timeline suggested by the source is so important.
Which is what?
Basically. Step 1, find out there's been a substantial change. Step 2, gather all your proof pay stubs, letters, whatever. Step 3, maybe consult an attorney or legal aid if you need help navigating the forms. And step 4, the crucial one, file that motion with the court as quickly as you reasonably can.
Don't sit on it.
Do not delay. That date stamp on your court filing paperwork is financially very, very significant.
Okay. Wow. So let's dig into those specific scenarios a bit more. What happens if the parent who is paying child support gets a big raise or starts a much higher paying job?
Right. So if the paying parent's income goes up substantially, the parent who is receiving the support absolutely has grounds to ask the court for an upward modification.
Makes sense.
Again, the first step would be to run the numbers, both parents' current incomes, through that guideline calculator. See if the potential new support amount hits that 20% and $75 threshold compared to the current order.
Okay. Like the example in the source. Say the paying parent used to make $3,000 a month, but now they're making $5,000 a month.
Right.
And let's say the calculator shows the new guideline support should be $700, but the old order was only $500.
That's a $200 increase on a $500 order. That easily clears both the 20% threshold and the $75 minimum.
So the receiving parent files the motion.
Yep, they file a motion, provide the proof of the income change if they have it, or ask the court to order the other parent to provide income verification. The court reviews everything.
And does it matter why the income went up? Like a promotion versus a temporary bonus?
That's a good point the source touches on. Courts generally look at whether the income increase seems stable and ongoing. A permanent new salary from a promotion or a new job. That's likely grounds. Consistent, significant overtime that's expected to continue. Maybe. A one-time large bonus that's not likely to repeat. The court might be less inclined to modify the ongoing support obligation based solely on that, though it could be considered income for other purposes, perhaps.
Okay, so they're looking for a more permanent shift in earning capacity.
Generally, yes. The goal is to base the ongoing support on what's likely to be consistent income moving forward.
Got it. Okay, now let's look at the flip side. What if the parent who is paying support sees their income go down? Maybe they got laid off or their hours were cut back.
Okay, so if you're the paying parent and your income drops, you may be eligible for a reduction in your child support obligation. However, this is an area where courts tend to be, let's say, much more scrutinizing.
Why is that?
They are very wary of situations where it looks like someone might be reducing their income voluntarily, perhaps to try and lower their support payments.
Ah, okay. So what kinds of income decreases will the court likely not consider a valid reason to lower support?
The source is quite clear on this. Things like just quitting your job without a good reason, especially if you have a history of steady employment.
Right.
Deciding to switch from full-time to part-time work without a compelling justification, like a serious health issue or maybe needing to care for a disabled child. Or intentionally taking a much lower-paying job than what you're qualified for, particularly if it seems like a move aimed at, well, punishing the other parent or avoiding obligations.
So strategic underemployment, basically.
Exactly. Courts generally won't reward that by lowering your support.
And this is where that concept you mentioned earlier comes in, imputing income.
Precisely. If a judge believes you are voluntarily underemployed, or unemployed meaning you could be earning more based on your skills, education, work history, and the job market, but you're choosing not to assign, they have the power to impute income.
And what does that mean practically?
It means they'll calculate your child support obligation based not on what you're actually earning at that moment, but on what they determine you should be capable of earning. They essentially assign an income level to you for the calculation.
Wow. Okay, so they can basically say, we don't believe you're only making X. We think you could be making Y, so we're calculating support based on Y.
That's the gist of it, yes.
Right.
Especially if you have a solid work history and marketable skills.
Okay, so if quitting your job or taking a deliberate pay cut probably won't work. What kinds of income decreases will courts typically consider legitimate reasons for potentially lowering support?
Generally, things that are involuntary, circumstances outside of your control.
Like what?
The source lists examples like getting laid off involuntarily as part of a company downsizing, being forced into retirement, developing a significant health problem or disability that genuinely limits your ability to work at your previous capacity, and you'll definitely need medical documentation for this.
Proof is key there.
Absolutely. Or maybe facing a major downturn in your specific industry that's impacting wages or job availability across the board. The key theme is proving the income drop wasn't your choice and isn't easily fixable.
And the attorney in the source strongly advises documenting absolutely everything if you're in that situation and seeking a decrease.
Essential. Cannot stress that enough. Keep copies of your layoff notice, proof you're actively applying for new jobs in your field, records of unemployment benefits, detailed statements from your doctor about work limitations, maybe even articles about economic conditions in your industry. Anything objective that backs up your claim. Courts need concrete evidence.
Right. Makes sense. Okay, we've talked about your income changing up or down. But what if your income has stayed pretty much the same, but your ex's income takes a big jump upwards? Can you still seek a modification based on their raise?
Yes, absolutely. And this is a really important point the source makes that people might overlook. Even if your own financial situation hasn't changed much, a substantial increase in your co-parent's income can definitely be grounds for you, as the paying parent perhaps, to seek a downward modification, or as the receiving parent to seek an upward one.
Okay, so their change impacts the calculation regardless of your situation.
Yes, because remember, the guideline calculation uses both parents' incomes, so you'd run the calculator again with your stable income and their new, higher income to see if it results in a change that meets those 20% and $75 thresholds.
And why is this particularly relevant in, say, shared custody or near equal parenting time situations?
Good question. It's because in Minnesota's formula, especially when parenting time is relatively close to 50-50, the final support amount becomes very sensitive to the ratio between the parents' incomes.
The difference between the incomes matters more.
Exactly. If one parent's income shoots up while the other stays flat, it can significantly change that ratio, and, consequently, what the guideline calculation spits out for the appropriate support amount. Filing a motion prompts the court to reevaluate based on both parents' current financial realities.
So it sounds like maybe keeping some general awareness of your co-parents' potential major career moves or income shifts,
Yeah.
at least when that information is reasonably available, might be relevant to your own financial planning.
It certainly can be. If you happen to know they finished a specialized degree program that typically leads to higher earnings, or they landed a major promotion you heard about, or switched to a much more lucrative field,
Right.
it might signal a potential income shift significant enough that it's worth, maybe running the calculator hypothetically, or considering whether a modification might be warranted, especially if you suspect their income has jumped enough to potentially trigger that substantial change presumption.
Interesting point. Now, beyond just income fluctuations, the source briefly mentions that Minnesota law does allow for modifying child support based on other special circumstances, too.
That's right. Income changes are definitely the most common reason people seek modifications, but they're not the only reason. The statute allows for it under other significant changes, too.
What kinds of things fall under that?
Well, the source lists a few examples, things like one of the parents becoming permanently disabled and unable to work,
Okay.
or, unfortunately, if a parent becomes incarcerated for a lengthy period. Also, significant changes in the child's actual needs, maybe major ongoing medical expenses that weren't anticipated, or specific educational needs, or even substantial changes related to housing costs directly for the child.
So changes related to the child's direct expenses.
Yes. And another big one is a substantial change in the court-ordered parenting time schedule itself. If the number of overnights significantly shifts from what was in the original order, that directly impacts the calculation.
Right, because overnights are a key input to the formula.
Exactly.
And what about if a parent has, additional children from a new relationship? Does that factor in?
Yes. The source mentions that can be a factor the court considers as part of the overall circumstances when deciding if the current order is still reasonable or fair. It doesn't directly change the income calculation for this child support order in the same way as the parents' incomes do, but it's a piece of the financial puzzle the judge can take into account when evaluating a modification request, especially if the income change itself doesn't quite hit that 20% threshold. It adds context.
Okay, so it's part of the bigger picture the judge might look at.
It can be, yes.
All right, so let's try to sum this all up. If you're listening and you think, okay, my situation or my ex's situation has changed significantly income-wise, maybe I need a modification, what are the absolute key practical takeaways or steps the attorney source recommends?
Okay, boiling it down. First, try using the Minnesota Child Support Guidelines calculator yourself. It's available online. Plug in the estimated new incomes and see what kind of number it generates. This gives you a realistic baseline. Is it likely to meet the 20% and $75 tests?
Step 1, check the calculator. Got
Step 2, gather rock-solid evidence of the income change. We keep saying this, but it's crucial. Recent pay stubs, W-2s, tax returns, letters from employers confirming new salaries or documenting layoffs, proof of unemployment benefits, medical records if health is the reason. Courts operate on proof.
Step 2, document everything. Check.
Step 3, if you can, it's highly recommended to consult with a Minnesota family law attorney. Even a brief consultation can be helpful. They know the local court nuances, the proper forms, how to best present your case based on your specific facts.
Okay, step 3, consider legal advice.
Step 4, and maybe the most urgent based on our earlier discussion about retroactivity. Don't wait. As soon as you have a basis and your documentation is reasonably together, file that motion with the court. Time is literally money in these situations.
Step 4, file promptly. Crucial.
And finally, step 5 is maybe more of a mindset. Be realistic. Courts are there to apply the law and the guidelines fairly. They aren't typically going to modify orders for very minor, temporary income fluctuations, and they're definitely wary if it looks like either parent is trying to manipulate their income just to change the support amount.
Okay, be realistic about the court's perspective. Makes sense.
Yeah, honesty and solid proof go a long way.
So, navigating child support when incomes shift after divorce in Minnesota. It sounds like there are definitely clear legal paths and those very specific numerical thresholds we talked about.
Right, the 20% and $75.
But also some important nuances, especially around whether an income change was voluntary or involuntary.
Absolutely. And this deep dive into the source material, I think, really shone a light on just how specific those Minnesota rules are, and maybe above all, how incredibly critical the timing of taking action is because of that retroactivity rule.
Yeah, that was a huge takeaway for me. Being proactive, really understanding these rules, and having your documentation in order, that seems to be the absolute key to making sure the child support order actually reflects the current financial reality.
Agreed. You definitely don't want to be stuck paying or receiving an amount based on an outdated order if your circumstances or your co-parents have genuinely changed in a way the law recognizes as substantial.
Well, this has been incredibly helpful. A really practical deep dive into a complex but really important topic for a lot of people.
Definitely. Very specific, actionable information from that source.
Yeah. So thinking about all this, here's maybe a final thought for you, the listener, to consider as we wrap up. Given how important those specific thresholds, the 20% and $75 are, and especially that strict retroactivity rule about the filing date, how might making it a regular habit to just generally track income changes, both your own, obviously, but also where it's reasonably possible, your co-parents' significant shifts become a crucial part of your long-term financial planning after divorce?
That's an interesting way to frame it.
I mean, even if you don't think you need a modification right now, just being aware, being prepared with the knowledge of how things work, could it position you much better to act quickly and effectively if circumstances do shift substantially down the road?
Yeah, turning sort of passive awareness into active preparedness. Knowing the rules before you need them. That's practical.
Exactly. Just a thought to keep with you. Thanks so much for joining us for this deep dive.
Always a pleasure. Looking forward to the next one.
If you found this podcast helpful, chances are you'll love the blog mancatofamilylaw.com. Also, the podcast is available on Spotify, Apple Podcasts, and wherever you listen. We cover real-world family law and divorce issues like parenting time schedules, child support changes, domestic abuse allegations and protections, and what really happens in a Minnesota divorce trial. Subscribe now and take control of your family law case, one episode at a time.